State versus Hank Maldonado. Can I have parties announced?
Andrew Harrison, State.
David McLean for the defense.
And are you Mr. Maldonado?
Yes, Judge.
In each of these cause number, you entered a plea of no contest. According to your plea bargain agreement, in each cause number, punishment is to be assessed at a cap of 12 months in the state jail facility. The state is opposed to your application. The cases will run concurrently.
Okay, pause right here. A plea of no contest with a 12-month cap means the defendant isn't admitting guilt outright, but he's accepting punishment as if he did. And here's the kicker. The state is opposed to his application. Or we're not rooting for probation. Already the odds are leaning toward jail time. The real question? Did his past just write today's sentence?
Qualified to say whether someone is addicted to substances or not. It does seem to me that 3 arrests over a period of 10 years for illicit substances, 1 case leading to a person being sentenced to confinement, seems to be serious negative outcomes that the persistent engagement in those behaviors would seem to indicate an addiction. Mr. Maldonado does not seem to...
This is where judges start connecting dots. 3 arrests over 10 years, revocations, failures to appear. When a judge says persistent engagement, what she really means is this isn't a mistake, it's a pattern. And in sentencing, patterns matter more than promises, because courts don't sentence who you say you'll become. They sentence who your record says you are.
To have a good track record of appearing when he is required to do so. His previous controlled substance case, he was ultimately revoked and sentenced to 2 years for the resisting and evading cases for which he is still pending. He failed to appear on December 1st of 2023. So going back to 2011 or going back to 2023, Mr. Maldonado seems to have an unfortunate tendency to not take his commitments to the court seriously. And based off of that history, it doesn't seem like he's going to be any more committed to meeting these requirements today.
All right, defense.
Your Honor, on behalf of my client, I reviewed the PSI and the TAP. The TAP evaluation seems to indicate that he does not have any kind of serious drug or alcohol problems. They were recommending basically urinalysis, not even an outpatient program. I think he's addressed those issues. In all candor to the court, we had a PSI set for Mr. Maldonado, and he did not appear, and he did take off for quite some time. I've talked to Mr. Maldonado about it, and he is basically just terrified of going to prison. That's really what it boiled down to. And with kind of this opposed type of offer, he was very nervous about coming in, and some people have a fight or flight, and he took off. And I tried, Your Honor, to get him back in, and it was just something that he was just too afraid to face. And that's just being honest with you. I think he could be successful on probation. I do.
Now this is interesting. The defense admits he ran because he was scared. That's honest, but legally, fear doesn't excuse failure to appear. Courts operate on accountability, not anxiety. And here's the tension. Is he a man overwhelmed by consequences, or a man avoiding them? Big difference. Judges here fight or flight and think probation requires showing up.
He's got a business. He works with his wife. I think it's something that he could be productive. He hasn't gotten in trouble while he's been out, which is not an excuse, but it is at least something where he's not just going out and reoffending again. We would ask the court to at least consider the application for deferred and place him on probation.
All right, Mr. Maldonado, you're scheduled to appear for court. You did not appear. That's a sign that you won't be a good candidate for probation. I'm looking at your criminal history. And you have a burglary of a vehicle from 2011. You were sentenced to 80 days in jail. Then you had a possession of marijuana, which I understand people see that differently now. That was dismissed because you were convicted of something else, which tells the court that it was taken in consideration. Then in 2011, you had a possession, penalty group 3, 28 to 200 grams. You were placed on deferred adjudication for 4 years out of the 186th District Court. Probation was revoked and you were sentenced. They amended it and just sentenced you to 2 years in the prison. And then in 2023, you had another case, book dismissed. And then you had these 2 cases that you were set to appear before the court and you failed to appear. How old are you?
33.
So you're 33. You're not a teenager. So why you would steal someone else's vehicle or...
There it is. When a judge says you're 33, not a teenager, that's more than commentary. It's a credibility assessment. Age removes excuses. At some point, the court expects maturity to kick in. And when it doesn't, patience runs out. This is the moment you can almost feel the sentence forming.
Use it without permission is beyond the court's understanding at a person your age. In each cause number, the court is going to find you guilty, sentence you to 12 months in the state jail facility. The cause numbers were run concurrently. Taking consideration 2024 CR 1039.
I apologize for interrupting. Is
Yes.
there already a dismissal form on file for that cause?
I'll have to have the clerks look and see.
What was the case number again, Judge? I'm sorry.
It's 2024 CR 1039. In each cause number, there's to be restitution and no contact with Richard Anthony Johnston and also Felix Francisco Citero Rivas. And I recommend the therapeutic community. He says he doesn't have a drug or alcohol problem, but there has to be something wrong with
That line right there. There has to be something wrong with you. That's judicial frustration on full display. The court is essentially saying either this is addiction or it's character, and neither option helps at sentencing. Also, notice the recommendation for therapeutic community, that structured rehab inside jail. So even in punishment, the court is nudging toward the treatment, consequences and correction all in one stroke.
you, or either you're just someone who likes to steal and take what doesn't belong to you. Did you review the documents entitled Trial Court Certification of Defendant's Rights to Appeal in each of these cause numbers?
Yes, I did, Judge.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, I did.
And it probably would have been in your best interest, well, not probably, I know it would have been in your best interest to have appeared on your sentencing date. Who knows what would have happened if you would have. All right, good luck to you.
Thank you, Judge.
You're welcome. Who's next?
Page 7. Second and third one for Lennon Cortez.
Lennon Cortez. All right, where are we on discovery?
I still need to get discovery. I had an issue come up here with Mr. Cortez.
Okay.
Verbal interactions, and I'm not going to be intimidated, so I'm asking for a motion to withdraw in this case. I don't feel that I can communicate with.
And just like that, we pivot to a completely different kind of courtroom drama. An attorney asking to withdraw because of intimidation? That's serious. When your own lawyer says communication has broken down, that's a red flag waving high. Pro tip: disrespecting your defense attorney is like unplugging your parachute mid-skydive. The judge's warning is clear: one more attorney. After that, you're on your own. And representing yourself in a felony case is rarely the power move people think it is.
Him I hate to do this, but, it's one of those situations. I don't need to be stared down. I don't need the intimidation. Maybe another attorney he can do better with.
Okay,
Try to give him his options, and, he doesn't want to listen.
all right, thank you. You're excused.
Thank you, Judge.
You're gonna get one more attorney. That's it. After that, you can represent yourself or you can retain one. Do you understand? Everyone needs to be treated with respect. I don't know why you think being disrespectful for your attorney will make your attorney want to represent you better. So just have a seat, an attorney will be appointed to you.